Hello, today we're talking about planning for unmarried couples, and this is episode 48 of Estate Planning Weekly. I am your host, Don Rolfe, the owner and founder of Northwest Legal Planning, an estate planning and probate law firm located in West Linn, Oregon. So, planning for non-married couples. And the people that I'm thinking of when I say non-married couples, I'm thinking of people that have been together a very long time. I have worked with couples that have been together longer than a lot of my married couples. 40, 50, 55 years without ever having tied the knot. And basically everything that they've accumulated in their life has been together. And everything that they have now when they're coming in to do their estate plans is jointly owned. They own it together. And planning for an unmarried couple is different than planning for a married couple. The number one thing that we look at is that if they have a lot of assets, we're not given that unlimited marital deduction where we can just leave as much to our spouse as we want, or in this case it would be to a partner, without having to incur estate taxes. It doesn't work that way with an unmarried couple. We don't do joint trusts either. So we have to kind of figure out, who owns what. Perhaps rather than owning things jointly, we might separate some assets and put some of it in partner A's estate plan and part of it in partner B's estate plan. But really what it boils down to is there are a lot of intricacies that do not apply to unmarried couples that do apply to married couples. So there is no spousal share. They could, partner A or partner B could leave everything to someone else that they own in their own personal name. Of course, anything that they own jointly is automatically going to pass. So if they own the house jointly with right of survivorship, the survivor will get the house. Same thing with bank accounts and all of that sort of stuff. So a lot of that is very similar that you would have with a married couple. But there are some differences, and it's always very fascinating to hear from people why they chose not to get married. And I don't want to share any too personal stories, but it is always very interesting to hear people talk about not being married for 40 years. And the one that comes to my mind, this man and woman had always intended to get married. They just kept putting it off every year. They would say, we'll do it next year or in 6 months, and that went on for 4 decades. So whatever the reason is, there are relationships like this, and there are special planning considerations that need to be taken into account. And what can even complicate it also is the fact that if there are children from that relationship, there can be some math things that have to go on, since the partner's not a spouse, where we have to leave a certain percentage to children, depending upon where what state we're in. Anyway, if you have any questions about this or any other estate planning topic, feel free to reach out to me. You can leave a comment below. You can go to myEstatePlanMeeting.com and schedule a phone call or an in-person consultation with me. And I'd be happy to answer those questions. If you like this comment, hit the like button, leave a review, leave a comment, share this with someone who you think might find this information useful, share it with the public in general. But again, if you or someone you know is in a long-term unmarried relationship, there are some special considerations that we need to take into account to do estate planning, or that you will have to take into account to do some estate planning, and I would really like to be able to help you with that or answer any questions that you have. Until next time, take care. Goodbye.